Good afternoon, ladies and gentlemen, and welcome to this, the latest in our series of Trinity Talks, in which we invite leading figures from the college and from public life to talk about their areas of expertise and interest with an audience from here, from the university, the city, and further afield. It's a very special pleasure this afternoon to be able to welcome my illustrious predecessor, but two, as president of the college, Michael Beloff KC. This is like one of those episodes of Doctor Who where you get two versions of the same character on screen at the same time. Michael served in the role from 1996 to 2006, and I'm reassured to see that he looks none the worse for the experience, which is hopeful for me. Once dubbed the godfather of sports law, Michael's going to talk today about how the high financial and, emotional stakes involved in the world of sport bring it into conflict with questions of law, politics, and morality. And he's addressed this topic recently with audiences as far afield as Beijing, Busan, and Riyadh. So this is something of a more a home fixture, slightly less far afield. I'm not going to describe, as I could, Michael's distinguished career in detail here, as he's going to be explaining how his professional interests started and have evolved during this talk. But for those left thirsting to know more about Michael and to hear from him, might like to know that he will be back here on the 28th of May to talk about his new book, Four Faces of the Law, those faces being advocacy, judges, history, and sport. And on that occasion, he's going to be interviewed by Dinah Rose KC, President of Magdalen, and Cato Regan, formerly of the Constitutional Court of South Africa, is going to be making concluding remarks. So that's something to look forward. But as for this evening, without further ado, let me ask you to join me in welcoming Michael. Thank you.
Well, thank you very much, President, for that generous introduction. You set me a challenging target with your remarks. Now, ladies and gentlemen, 10 and 5-pounders all, the title of my talk, which was given to me, not created by me, is more of a bouillabaisse than a clear soup. But mercifully, it gives me some discretion as to which items to give prominence. It's also ambiguous as to how I should treat the items that I select. The poster says, quote, "Join us to hear about how some of these high-profile issues have been dealt with by Michael Beloff KC. I construe that to mean that I'm expected to speak not only about the issues in the abstract, but to flavor them with items from my own sports law casebook, whether I was dealing with those issues as counsel or arbitrator. Well, so be it. I shall have to bear that burden with such fortitude as I can muster. I shall first talk and then open the subject up for question and answer. It won't be quite like a game of two halves, because my split is 40 minutes talk, 20 minutes question and attempted answer. Let me briefly mention my credentials to address the subject at all. My first case as a sports lawyer dates back to 1967, and I argued or advised on cases for more than 4 decades after that. I then gravitated to deciding cases as an arbitrator, with more prestige but significantly lower pay. First, as a member of the Court of Arbitration for Sport, CAS, often called the World Court of Sport. In addition to a regular docket of cases, I arbitrated as a member of special ad hoc panels at 5 Summer Olympic Games and 3 Commonwealth Games. I became chair of the Ethics Committee and Disciplinary Tribunal of 3 global sports, in chronological order: cricket, athletics, and lastly, skiing. So you might cynically observe that my career as a sports disciplinarian has been downhill all the way. I was also SEBCO's ethics commissioner for our London 2012 bid. And I was a member of the Formula One International Appeal Tribunal for 10 years, during which I had just one case. That was, in fact, 50% of the cases that body had over the whole decade in its beautiful premises and headquarters of the Place de la Concorde. But for better or for worse, it's that experience that provides the theme for my talk today, that the main purpose of sports law is to promote competition, which is not only effective and exciting, but above all fair. So let me fire the starting gun and, to mix the metaphor, kick off with extracts from the opinion of the Advocate General Capeta of the Court of Justice of the European Union. For bad, good or bad, few passions are as widely and as profoundly shared around the globe as the passion for sport. It brings out the noblest human qualities and the basest. It is also big international business. Its capacity to motivate vast populations is nothing less than fabulous. To put it somewhat more pithily than Madame Capeta, sport is important in a large number of areas, and that is why fairness of sport is so important. There's no near unanimity, apart from the apostles of the so-called enhanced games, that the results of sporting competitions, other than e-sports, whose credentials as a sport at all have been recently thrown into doubt by the International Olympic Committee, the IOC, that they should depend upon a combination of skill, application, tactics, playing conditions, and even luck. There's a great South African golfer, Gary Player, famously said, "The harder I practice, the luckier I get." I will take the topic in stages. First, the rules which describe the content of a particular sport, a match's length, the weight of a discus, the curve of a running track, are not themselves designed to promote fairness. They're constantly under review by sports governing bodies, influenced by quite other considerations, such as the demands of television, tie breaks in tennis to prevent the extensive becoming the eternal, the safety of participants, changing what kind of tackles are permissible in rugby, the enjoyment of spectators. To give a single example, the width of a goalmouth designed to give an equal chance to one side's outfield player to score and the other side's keeper to save. It has nothing to do with fair competition between each's teams. These rules are not in themselves justiciable, unless maybe unthinkably they contradict the law of the land. Boxing is an exception. As a law lord once said, it is best to regard this as another special situation which for the time being stands outside the ordinary law of violence because society chooses to tolerate it. Now, Trinity is a college with a great sporting tradition. It has produced one gold medalist in the Olympic premier sport, athletics, Bevel Rudd, a South African Rhodes Scholar and the 400-meter winner at the Antwerp Olympics in 1920. Another famous Trinity athlete, the English Walter Henderson, was a double Olympian. He participated at the White City in 1908 in 6 events: the standing high and long jump, the discus freestyle and classical style, the javelin freestyle and held in the middle. Only the discus classic style arguably survives in the Olympic calendar, not because the other 4 events did not test the physical and mental capacity of the athlete, but because the modern replacements are thought to do so no less well as to produce more impressive results in terms of height or length. Those changes have nothing to do with fairness at all. But second, in the organization of competitions in any sport, old or new, concepts of fairness do have a critical role to play. Most notably, disability sport has its own distinctive regime, since an able-bodied person has an inherent advantage over a disabled one. The South African athlete Oscar Pistorius, popularly known as the Blade Runner, wanted to run in the 2012 Olympics as well as the Paralympics, and won a case before a CAS panel. The panel held that the international federation which wanted to stop him had failed to prove that his prosthetics gave him an unfair competitive advantage over his able-bodied competitors. A few years later, I advised World Athletics that it ought logically to be for the athlete who wanted to compete with the use of prosthetics to prove an absence of advantage rather than the other way around. But another CAS panel said I was wrong. Well, as an advocate, you win some, you lose some, a bit like sports people when you come to think about it. Now, the rules of disability sport are exceedingly complex and need someone with the brain of a Cambridge senior wrangler to understand them. Only yesterday, it was revealed that Alexa Leary, a 24-year-old swimmer who had overcome significant challenges after a traumatic brain injury, has been barred from competing at the Commonwealth Games due to her reclassification from the S9 to the S10 category by World Athletics, apparently not World Aquatics. This change means she can only compete in the 200-meter individual medley, an event in which she does not participate. Work that one out if you can. There are other examples in the same category of different treatment in the interest of fairness. Most sports, in pursuit of the same objective, provide for competitions for different age groups, youth, juniors, and at the other end, various categories of masters, including, to purloin a phrase from the world of art, not of sport, some very old masters, like the centenarian Sikh marathon runner Fujal Singh, who was literally in a class of his own. Many sports recognize the need to differentiate between classes of competitors by reference to weight. Boxing has a number of different categories. Rowing has a mere 2, lightweight and the other. And what animates these distinctions is science, and notably biology. And there's little which excites controversy about them. Nor is there argument about the most significant dividing line in sporting competition, that between men's and women's events. That line is embedded in almost all sports, other than notably equestrian, where the horse eliminates the impact of the human difference. But whereas disputes about whether a competitor fits into an appropriate age category can be resolved by an authenticated birth certificate, or in an appropriate weight category by a set of accurate scales, whether someone is or is not a woman for sporting purposes is a matter of vigorous dispute, and in particular in the United States, one with a highly political dimension. President Trump would exile all transgender women from competitive sport, including in the 2028 Los Angeles Olympics. His attitude towards women with different sexual development, or DSD as it's called, such as the double Olympic champion 800-meter runner, the South African Caster Semenya, is unknown, but it's likely to be the same, whether in the morning, afternoon, or evening, unlike some of his other policies. In March of this year, the IOC proposed the introduction of genetic sex testing and a ban on transgender athletes from the Olympics from 2028 onwards, following in the footsteps of World Athletics, World Boxing, and the International Ski and Snowboarding Federation, and, surprise, surprise, the International Chess Federation. Since then, it's been copied by the darts regulatory body, no doubt causing Luke Littler, Luke the Nuke, to breathe a sigh of relief. Now, more than 80 human rights organizations have criticized this policy as contradicting the IOC's 2021 framework on fairness, inclusion, and non-discrimination, as well as being based on stigma rather than science. Now, I myself had advised both the IOC and World Athletics on the validity of previous regulations designed to ensure that DSD athletes could not compete in women's events without taking steps to lower their testosterone levels. Those regulations, once they were in force, spelt an end to Caster Semenya's successes. When she obeyed them, she was never the same athlete again. And she's now retired to become a campaigner, though she's apparently abandoned her legal action to have those regulations actually set aside. Now, the same considerations which animated her challenge must logically apply to transgender athletes too, and the reasoning is simple. All sports rules designed to ensure fairness have a basis in biology and nothing less, so that to allow self-identification as the criterion for participation in women's sports would be wholly anomalous. Now, speaking of anomalies, now that Chinese robots' 2026 version can outrun the best human athletes over the half marathon distance, unlike the 2025 version, which collapsed in a jangling heap at the start, a ban on them competing against humans in the same race, other than by way of exhibition, is surely a must. The concept of fairness applies to team sports too. I once failed to persuade a CAS panel in a case called ENIC, where one person owned two teams in the same football competition, that there was no unacceptable risk that results could be manipulated in the owner's commercial interests. That was, in my personal view, clearly the right decision. But I'm less convinced myself by the modern financial fair pay regulations for football clubs, said to make the playing field more level, if certainly not completely flat. They seem to me like taxes to be capable of avoidance, if not evasion, with the assistance of expert financial advisors. Manchester City faces 115 charges brought by the Premier League for breach of those regulations by, it's said, artificially inflating its revenues over a period of 9 seasons between 2019 and 2018. This remains unresolved after more than a year of deliberation. It was so much simpler, like most things in the good old days. In 1995, I persuaded a special tribunal that the triple penalty imposed on Spurs for the financial irregularities of a previous manager was, in legal language, disproportionate and, in football parlance, over the top. Only a fine of those triple penalties survived a panel's decision, which was then reached in little over a week. For that, I was called the true hero behind Spurs' incredible comeback, if only, alas, in the Daily Mail. Now, all sports, in the aim to achieve, as far as possible, equality of opportunity between athletes, must also have rules as to what clothing and equipment can be used. The boundary between what legitimately improves performance is constantly shifting. From the start of 2020, swimmers were no longer allowed to wear the full-length, body-length polyurethane and neoprene suits during competition. Those suits had assisted Michael Phelps in his medal-winning exploits in the Beijing Olympics, though it's a consolation that the ban did not prevent him from accumulating yet further medals in London and Rio. In this year's London Marathon, the 2-hour barrier, once thought like the 4-minute mile to be untouchable, was broken by the Kenyan athlete Sebastian Sawe. Given that country's poor record for breach of the anti-doping rules, doubt has been promptly cast on Mr. Sawe's achievement, though it's unsupported by any actual evidence. But he himself modestly conceded that he was assisted by his state-of-the-art footwear, and world athletics may yet have to tighten the regulations about the permissible components of so-called super shoes, whose cost puts them beyond the reach of most people. Fair competition has, of course, its enemies. Forms of sport-specific cheating are many and various. Selecting ineligible persons for a team, claiming non-existent or less serious disabilities to improve one's classification in Paralympic sports, misrepresenting one's age by lowering, not increasing it, to improve chances of winning not so much the races themselves, but the prize money which often goes with them. Breaking the rules as to engine construction in motor racing or as to ballast in yachting. I was party to awards in cases which involved both those breaches, somewhat implausibly, since I took 42 lessons to pass my own driving test, which may, for all I know, be itself something of a record. And as for manoeuvring boats, well, I never got past punting. Happily, my decisions were all based on departures from process, our present, if interim, Prime Minister's favourite word, said to have been followed in the appointment of Peter Mandelson as ambassador to the court of King Trump, after Mandy had missed a podium place in the race to become Oxford Chancellor by coming only fifth. Equipment manipulation is a classic example of cheating. Shortly before the Winter Olympics Milano Cortina, I chaired a panel of the International Ski Federation's disciplinary body. Its governing body had charged 3 senior officials and coaches of the Norwegian ski jumping team with wrongful alteration of their suits before last year's World Championships in Norway. They did so by sewing a stiff patch into the crotch area, said to make the suits more aerodynamic. Now, this may sound to all of you in terms of technology more Wright brothers than Concorde, but the effect was not in dispute, and the officials were convicted and disqualified for 18 months. In a sequel to what was already a somewhat tangled tale, allegations were then made that male ski jumpers were injecting their own genitals with a substance to stiffen them up, with apparently the same aim and effect. The international media predictably failed to resist the temptation to call this penis gate. Now, ball tampering in cricket is, I suppose, a cousin of equipment manipulation. I've authored 2 decisions involving, respectively, the captain of the South African team, Faf du Plessis, and of the Sri Lankan team, Dinesh Chandimal, and they both involve the delicate questions of whether, and if so when, the deliberate application of saliva to a cricket ball was a breach of cricket's rules. Did I really study law at Magdalen to end up pondering on questions of that gravity? Now, corruption, hyper-cheating, does occur where there is match or spot fixing, and competitors, by action or inaction, distort results, usually to facilitate a betting coup. The best-known example occurred in the Lord's Test in 2011 between England and Pakistan, where 3 Pakistani bowlers deliberately bowled no balls at the behest of the so-called fake sheikh. I chaired a panel in Dubai with the anti-apartheid activist and judge of the South African Constitutional Court, Albie Sachs, and a former Attorney General of Kenya, Sharad Rao. We were comfortably satisfied, that is the standard for proof that is specific to sports disciplinary cases, that the charges had all been made out. And it was some consolation that all 3 of the bowlers were later found guilty at the Old Bailey of crimes arising from the same basic facts, and their punishment upheld on appeal by the then Lord Chief Justice, the very aptly named Lord Judge. Match officials, too, have been involved in such intrinsically corrupt activities. I chaired a panel which found that a referee had taken bribes to influence the result of a football match. It's usually at the lower levels of the game, cricket or tennis, that this kind of malpractice occurs, especially with the growing addiction to gambling, not least in China. It has become, at any rate, proximate, if I can put it that way, in its damaging effect on sport. But the most obvious example of cheating in sport is doping, the use of performance-enhancing drugs policed since the turn of the century by the World Anti-Doping Authority, WADA. Results achieved by an athlete tested positive for such drugs will be set aside even if the athlete bore no responsibility for their presence. The athlete's degree of fault affects only the penal period of ineligibility. That's the barest summary of the lengthy and complex World Anti-Doping Code. And I was instructed last year by WADA to vet the next version, effective from 2027, for its compatibility with human rights principles. That's another example of the growing impact of the concept of fairness in sport. I want to mention only 4 doping cases out of the scores in which I was involved to show the kind of issues which arise. I prosecuted for the International Athletic Federation the Greek sprinters Kenteris and Thanu, who were poster persons for their home Athens Olympics as potential medalists. In the run-up to the Games, they were as elusive as the fictional Scarlett Pimpernel, or nowadays the actual Sarah Ferguson. They were never found in the place where they were thought to be for the purpose of out-of-competition testing, and on the eve of the Games, they were carded for another test in the Olympic Village itself, for which they failed to appear, pleading an accidental motorbike incident. This excited widespread incredulity. It led to their summons before an IOC disciplinary body, after which they withdrew from the Games, as they put it somewhat tactfully, in the interests of their country. In the end, the International Federation accepted a plea of failure to appear for the mandatory third test, though I firmly believe to this day that they were guilty of deliberate evasion on a very grand scale. I defended Alan Baxter, known as the Highlander, whose Olympic bronze medal for the slalom at Salt Lake City was removed because the American version of the Ventolin he used to combat his asthma contained, which the British equivalent did not, a prohibited substance. Baxter's misfortune was that the packaging was the same on both sides of the Atlantic. He simply failed to read its small print. How many of us are guilty of the same sin on a daily basis in a variety of situations, usually without any adverse consequences at all? The CAS panel acquitted Alan Baxter of cheating, but did not and could not restore his medal. I defended as well Christina Hurrigu, the 400-meter runner, who is the poster girl for this talk. She'd also failed to appear for a third whereabouts test, and so was in breach of an anti-doping rule. And she was sanctioned for a short one-year ban only, because there was never any suggestion that she deliberately tried to conceal doping. The next issue was whether, after her ban was at an end, she could compete for Team GB in the Beijing Olympics. I, with my barrister son as my second junior, all acting pro bono, persuaded a panel that her missing of the third test was an excusable accident. And I had the special pleasure of watching Christine from a seat in the Bird's Nest Stadium in Beijing win Team GB's only track and field gold in those games. That was a giant step for Christine, maybe a small step for me too. I chaired a three-man panel to determine the penalty to be imposed on Jack Jones, a mixed martial arts specialist said to be the most dangerous man in unarmed combat in the world. I was a little concerned to be facing Mr. Jones across a small table in the arbitration room in Malibu, until I reasoned that he was unlikely to improve his chances of a favorable award by attacking any of the arbitrators. His defense was he'd been taking Viagra, not a drug which enhances sporting performance, and that it must have been contaminated with such drugs at the manufacturer's laboratory. I'll never forget his last words in giving evidence about the occasion when he took the stimulants, anticipating a romantic night with a young lady friend. He put it wistfully, "I didn't even score." There are, of course, a multitude of reasons why the best competitor might not always receive the right reward. In taekwondo, gymnastics, freestyle, skiing, snowboarding, figure skating, boxing, diving, or dressage, much depends on the subjective views of the judges. Beauty, as they say, and not only in sport, lies in the eye of the beholder. But where sport is performed at high speed, as for example in diving, the judges must rely for its evaluation on their naked eyes. They are in effect human databases trying to operate at machine speed. Only AI might provide a solution by showing what happened frame by frame, allowing the judges then to make a judging on the actual facts as the aesthetic merit of the performance. But sometimes judges have indisputably made a simple error. In the final of the men's all-round gymnastics at the Athens Olympics, the American Ham's gold medal win came after the Korean competitor Yang was misscored on the difficulty of his exercise in the parallel bars, the penultimate event of 5. The difficulty of an exercise is a fixed matter of classification, requiring, unlike the exercise of performance, no element of evaluation at all. Yang appealed to CAS, but the panel which I chaired had to dismiss the appeal. Why? Because of the so-called field of play rule, which immunizes a match official's decisions from review unless it's infected by some form of arbitrariness or corruption. Another obvious limit on the opportunity of the best competitors to come out on top is politics. The new president of the IOC, Kirsty Coventry, has said, "We are a sports organization, we understand politics, we know we don't operate in a vacuum, but our game is sport. That means keeping sport a neutral ground, a place where every athlete can compete freely without being held back by the politics or divisions of their governments." But it ain't necessarily so. Can is not the same as does. In 1980, Mrs. Thatcher expressed a wish for a boycott of the Moscow Olympics in response to the Russian invasion of Afghanistan. I had no difficulty in advising 2 former athletes that even the Prime Minister's wishes were not law, much though she may have thought otherwise. So Everett and Co. were free to go, but not so the athletes of the United States. They obeyed Jimmy Carter's command to stay at home, and in a classic tit-for-tat, no Soviet bloc athletes came to Los Angeles in 1984. We can but speculate on how politics will affect participation in LA 2028 in defiance of the Olympic Charter, whose objects are, and I quote, "to maintain and promote its political neutrality and to preserve the autonomy of sport." Now, those who run international sports have a built-in bias to maximize their membership and boast of its numbers, but they too can succumb to contrary political pressure. I led the legal team which, after 3 rounds before CAS, won admission of the Gibraltar Football Association to the governing bodies of European and world football, so long resisted by Spain, although Gibraltar satisfied the formal criteria for admission to those bodies apply to other non-sovereign countries like the Faroe Islands. I am, however, wholly confident in saying that this result, much welcome on the rock, is never, ever likely to affect the destination of the Football World Cup. But I failed to achieve similar success on behalf of the South African Athletics Federation to join the international body at a time when the apartheid regime was in place. It took Nelson Mandela to achieve that aim. The most recent example of the influence of politics on sport is the reaction of the sporting world to the Russian invasion of Ukraine. Out of any competition run by World Athletics, half in, half out of the Summer Olympics, with only vetted individuals competing as such and not as members of a team. In football, Russian national teams and clubs were suspended from all competitions by both the European and global bodies. And I was one of the CAS panel which dismissed a claim by the Russian Football Association to set aside that suspension, but our decision was expressly and deliberately made on practical, not political grounds. You may all have noticed that even while the war in Ukraine continues, there is a perceptible erosion of enthusiasm in the sporting world to remain in the front line of those who react against it. Gianni Infantino, head honcho of FIFA, said that the football ban has achieved nothing, and it's certainly not the end of the conflict. And Kirsty Coventry has signalled a possible return by a Russian team to LA 2028, while accurately noting an inconsistency in the target for such bans, such as continuing conflicts in Africa, without the suspension of the countries involved. But only last week, the IOC reopened the door to Belarus. World Swimming will now allow swimmers from Russia to enjoy their flags, colours and national anthems as part of a national team. World Taekwondo and the International Judo Federation have followed suit. And the International Paralympic Committee broke ranks entirely, and in Milan Cortina this year welcomed all qualified participants from whatever country. Its president, in his speech of welcome, said the Games were a barrier-free community where potential is realized and opportunities open to all. And on May Day, Iran's Minister of Sport and Youth asked for Israel, not the USA, to be suspended from international competition following what he described as an American Zionist-imposed war. Now, bans may delight politicians, but they can devastate players whose short careers may be interrupted, even ended by off-field decisions in which they played no part. And there is some solidarity between sports people who not only wish to be the best, but to play against the best. In my role as chair of the International Cricket Council's Dispute Resolution Committee, I presided over a hearing in which the panel dismissed a claim by the Pakistan Cricketing Board for substantial compensation from the Indian Cricket Board, who had withdrawn its team from a proposed series in Pakistan at the direction of its government. We did add this pious postscript to our decision. The panel was forcibly impressed by the sincere desire of witnesses for both sides who displayed such mutual respect and even friendship for the resumption, were it feasible, of bilateral tours between teams representing these two proud cricketing nations. The panel expresses the hope that political considerations will not long prevent that desire from being fulfilled. Well, fine words butter no hard politics. Our hopes remain unfulfilled, and just on Friday, the Indian government reiterated its ban on such reiterated its ban on bilateral matches. I've had to ask myself, how often am I going to need to revise my text for this talk? The world of sport stops revolving for no man or woman. Climate, as well as politics, can affect outcome and opportunity for sportsmen and women, sometimes in combination. In host city selection for major competitions, athletes' well-being has rarely been a major consideration. The choice of high-altitude Mexico City for the 1968 Olympics utterly destroyed the chances of the multi-world record holder and distance runner, the Australian Ron Clark. And the curious award of the Football Club World Cup to near equatorial Qatar in 2022 was only mitigated by a later change of dates to winter months. Seb Coe has said the international calendar for Olympic sports may need to be re-engineered because of climate change. And the president of the International Ski Federation has spoken of the existential threat to winter sports posed by the same phenomenon. Fairness in competition, fairness in access to competition, not the same. In his line, "Some mute inglorious Milton here may rest," from his elegy written in the country churchyard, Thomas Gray in the 18th century reminded the reader that lack of opportunity may prevent someone with the inherent talent from becoming a great poet. And in the 20th century, Thomas Murray, the sports ethicist, suggests that somewhere in the world of children suffering from displacement, poverty, or simple lack of parental support, there might be a sprinter of boat-like speed had he lived a life without those disadvantages. We shall never know. For in sport, success can only be measured by results actually achieved without cheating. In the Black Sox scandal of 1919, sometimes described as the sports scandal of the century, the famous American basketball player, Shoeless Joe Jackson, was found to have thrown a match. A distraught fan, not wishing to believe that his hero had not only a golden arm, but also feet of clay, uttered the unforgettable and poignant words, "Say it ain't so, Joe, say it ain't so." The best we can do is to strive to make sure that in sport it ain't ever so. I say strive, for after all, life isn't always fair either. Thank you very much. So we now have time for some questions, if anyone wishes to ask them, and someone no doubt has got an ambulant microphone.
A long time ago, I saw a film in which an actor called Ian Holm, as I remember, trained a bloke called Abrahams to do incredibly well in one of the Olympics. And I suppose it gave me a very sort of innocent impression about sport, because there didn't seem to be any suggestion of any legal implications or involvement and so forth. I don't remember what year that was supposed to be.
Paris, 1924.
Gosh, I was hoping to catch you out on that. Anyway, to 1924. So, but when did the law start getting a grip on the game, or was it the other way around? Did the game insist on the law becoming involved because it became so complicated? Over what period, in what period did people like yourself add so much to sport?
We're
very grateful that you did get involved, obviously.
I mean, the answer is it was very, very slow burning. I mean, I mentioned that the first sports case I ever did was just after I'd graduated in 1967. But I didn't actually do another case for 20 or 30 years. And what has changed sport, as has changed so much in our lives, is, of course, the influence of money. It didn't really matter, except of personal pride and so on, if one did or did not win a race, or if one's team did or did not succeed in the cup. But nowadays, huge amounts of money turn on it. You can make a fortune if you're a gifted marathon runner, for example, or a successful football team. And the moment money comes into the field, then, of course, lawyers follow it. And that's the impetus of the development, and it's a relatively recent impact. I would suggest not really much before the 1980s. Yes.
Thank you. That was a wonderful talk. And I have a few questions about fairness, because you made great play of the fact that the aim is to try to make everything fair. But of course, nothing is ever fair, because we are genetically different and we have different backgrounds. And so our physiology will be quite different. And I'm wondering then about two things. One is about the disabled athletes who have, obviously they have blades or they have other things, other prostheses that enable them to move, to run, to swim maybe. Is there something there which ensures that they all get the same quality of prosthesis? Because I imagine that if you come from outer Mongolia, you're not likely to have such a good one as perhaps if you come from the United States. So that's question one. And if I may, another question, which is about the training regime, because we all know now that one of the things that the runners are doing is extreme carefulness in what they eat and when they eat, and these intensive training programs, especially for cyclists and things, which enable them to go faster than ever before. And not everybody has access to those training programs or the food. So how do you ensure fairness in that?
Well, I mean, the answer is you can't iron out every kind of inequality, either of physiology, though, as I say, the rules of sport do try, especially in disabled sport, to calibrate in a very difficult to understand way of the difference. But in relation to access to facilities, what you say is clearly right. Luckily, in the days of, as it were, global travel now, international travel, you find, I mean, for example, the inherent advantages from athletes from the Rift Valley in Kenya, or indeed in Ethiopia with the mountainous climate and the ability to train at altitude, is an advantage to them, but it's beginning to be compensated for by the fact that for example, star British athletes go and train in these particular areas. I mean, that's one way in which, as it were, the richer countries compensate for what might otherwise be a disadvantage vis-à-vis people from the poorer countries. But you can't eliminate it entirely. And as you rightly say, if you look at it in reverse, are those from the poorer countries able to get the same opportunities as those in the richer ones? Well, obviously not to such an extent, though of course nowadays, because sports become very political and prestige is very important and is earned by having winning athletes and winning teams, then of course you do get state sponsorship to some extent, addresses the balance. But no one's ever going to pretend that all inequalities, either of physiology or of wealth, are going to be ironed out entirely, which was, I hope, I ended by saying we should strive to do the best we can, but we can't do everything. And as I say, going back to what Thomas Gray said about poets, and Tom Norris said about sports people, there it is. There are people who, in different circumstances, might have achieved results of which we can only dream, but we'll never know. You can only do the best you can with what you then have.
I've got a question on the kind of enhanced Olympics and what your thoughts are there. Do you think it's going to impact sport in any way?
Well, I mean, I think it's appalling. I mean, anyone who's seriously interested in competitive sport is appalled by the notion that people could be free to take any kind of substance they wish which enhances performance, not least, of course, because the potential for long-term damage to their health. You can understand why people, mercifully now only those who are in the twilight of their career are participating, because they are going to earn more in a single lap than they would probably in the whole of their careers. But it's not going to be a pathway to a future. It's going to be an aberrant and eccentric activity. The fact it's being located in Las Vegas tells one really a lot about the morality of it. And all the major sports governing bodies are firmly opposed to it, not only because they're self-preservation, because they will be preserved without any challenge effectively from the enhanced games, but to ensure as best they can proper care for the athletes for whom they once bore responsibility and for whom they still feel, no doubt, a moral sense of obligation. Yes? Professor Kemp. There is one, I think, behind, being passed down like a baton in a relay race.
Yeah, terrific lecture. I'm wondering about the personal aspect of it, which you encounter in things like Caster Semenya, who I felt rather sorry for. You know, this is somebody who is eliminated from taking part, but wasn't consciously cheating. And I'm just wondering how far, with these big public cases, you think you're moved to think, well, legally we've reached the right dimension, but emotionally and psychologically and personally, we've run up against something which is very unpredictable and very unhappy.
Well, I agree. I mean, I have very considerable sympathy for her and the way in which she was treated. I first encountered her as a spectator in the World Championships before the Beijing Olympics. I think that's right. But in any event, I was marveling at the fantastic race she was producing. And someone very high up in the British athletic hierarchy came up and said to me, we were just talking, but Michael, you have to understand, she's a man. Well, be that as it may, it's a crude description of what they were thinking of at the time. The difficulty for her was the extraordinary amount of publicity that she got, the fact that she wasn't properly protected by either the International Federation or her national federation. And I think it's amazing that she's come out, in a sense, as well as she has now. As I say, her athletic career went into a dip because of the regulations designed to eliminate what they thought was unfairness. But she has become a very successful author and a very successful campaigner and a high publicized figure. But I wouldn't have liked to have gone through the experience that she went through for all the benefits that she may have collaterally and indirectly got from it. So I do agree, your fundamental point, Martin, this is no fault of hers. She was brought up as a woman. She believed she was a woman. As I say, I'm not an expert in genetics or biology. There are obviously ambiguities there, but none of her fault. What can you do? You have to balance the other athletes' interests against hers. I mean, I will tell you just this, if we've had a little time. I mean, I was at the Rio Olympics, and I was watching the race. She won the race. Number 2 and number 3 were all athletes with what we call differences of sexual development. You have to feel sorry for those who came 4th, 5th, and 6th. They'll never retrieve the medals, but if the regulations which presently ban her had been in place, had been in force at that time. So it's not all one-sided. Sport has its grey areas, and you have touched very properly on at least one of them. Anyone else? Yes? Young lady behind.
I have a general impression, which may be erroneous, that pretty much everybody observes the Court of Arbitration for Sport as the ultimate adjudicator on things. A, is that a fair impression? And B, how the heck do you get so many different sporting bodies happy to defer to CAS as the ultimate arbitrator?
Well, it's interesting. I mean, it was founded by Samaranch, Marquis de Samaranch, in order to remove sport-related issues from the courts of law, which they were thought incompetent properly to adjudicate upon, simply through lack of awareness or knowledge and so on. And as a mission, I think it was very important. It started quite slowly, and it was only over the last 20 years or so. I remember when football first joined. I remember the sport I'm particularly interested in when athletics decided to join, and now all Olympic sports have joined, and the only ones that are outside are ones with their own tribunals, like, for example, the Formula One International Appeal Tribunal, and, of course, examples of American exceptionalism, American-specific sports like American football. Is it a good thing? Yes. It's a good thing in a sense that they now have something like 600 members from all areas of the globe. All of them have to be qualified as either as experts in law or sport, or preferably both. All of them can serve, but there is a selection process in which either side in an issue can choose their own arbitrator, and then the panel president or chair is selected outside. And there have been criticisms that it's been slightly a closed system, but it's not actually that closed. If you've got a choice, possibly out of 600 arbitrators, it's rather better than you might get if you were litigating. There are other aspects that have been, I think, improved. For example, now, it used to be all in private. Nowadays, an athlete, a sports person, who is the subject of a disciplinary charge for breach of any rules can ask for it to be in public, and it will be subject only to very exceptional circumstances like national security. By chance, years ago, I was arbitrating in a panel about the famous the Irish swimmer, Michelle Smith de Bruyne, who won 3 gold medals, to everyone's surprise, in the 1996 Atlanta Olympics. And no question was placed over her triumphs at that stage. But a few years later, she was in fact found guilty in an anti-competition test by having prohibited substances in her bodily fluids. In fact, it was the test showed that there was also an overlay of Irish whiskey, which was found to have her method of trying to conceal what she had done. But to cut that tale short, her counsel, an Irish, very voluble and engaging figure, said, "I'd like this to be heard in public." Never been done at that time, but there was no reason actually to stop it if that were her wish. It was held in public, but absolutely no member of the public attended at all. And as I say, it took for another, 20 years or so before the Court of Arbitration, the European Court of Human Rights, decided that in those limited circumstances, if the athlete, the subject of the charges, wanted it, it should be in public. But that's just an eccentric anecdote from my own casebook. Yes. We've got two now. Okay. We'll have ladies first and then men second.
Hiya.
That's equality of treatment, as best I can achieve it.
I have a question on the definition of sport. So you mentioned, you offered one earlier, but you kind of implied that it was vulnerable, with some of the newer sports that have been added to the Olympics. Obviously, breakdancing was a bit more of a recent addition and controversial addition, and there are other dance disciplines. I don't know, something like ballet, which is obviously also a very physical discipline. I was wondering whether you have like a definition of sport that you subscribe to, and what do you think are the kind of criteria for a sport to make it to the Olympics?
Well, the only definition I think that I would have, and it was one actually that was approved by the European Court of the European Court of Justice, as it was then called, in a case about bridge, and it was all to do with tax advantages or disadvantages of being classified as a sport, that there must be at least a minimum of physical activity in the sport. Beyond that, as you rightly say, there are a whole range of ones. A dance is an obvious example. I mean, if you have gymnastics, why not dancing? Why not figure skating, etc., etc.? Some of these are sort of cousins, if they're not exactly brothers or sisters. And I think it's just a choice that's made. Obviously, things like break dancing and so on, because it attracts a larger audience, and therefore money again speaks to that. But in the Olympic calendar, it's constantly changing, and it's changing partly depending upon where the Olympics are being located, so that you would favor sports that were particular to that area, and partly because of the kind of audience that you expect to get, whether directly or through television or other media. And there's no absolutes. And as I say, for my part, I would just simply say physical, not mental. After that, I will rely upon the discretion and good sense of the International Olympic Committee as to what they allow in negotiation with the host city, and where you could cut it innumerable ways. And mercifully, I'm not one of the people who's ever had responsibility in that aspect of the sport.
Michael, thank you very much for a fascinating talk. I just wanted to drop 2 bits of history into the end of it, if I may. One is to comment on the enhanced Olympics question that was asked earlier. And that is to remind ourselves, as I was doing a conversation with some people the other day, of the consequences of use of substances which otherwise are thought to be unsuitable, harmful or unfair, in the context of the way that they were often forced on athletes behind the Iron Curtain. And you look at some of the misfortunes that some of the people who competed, particularly in endurance sports, on behalf of East Germany and other countries, and the terrible troubles that some of them are still having as a result of the physiological changes that made on them. And if anyone needed a lesson as to why not to do this, that's probably a pretty good one. And then on the earlier point about when did we start getting involved in or generally did arbitration or whatever need to come in, and you mentioned the 1980s, which seems to me a pretty fair spot. But in 1881, your predecessor as president of this college actually intervened over a matter at Henley Royal Regatta, which I happened to have on my phone because I was giving it to somebody the other day when, I won't read it all, but there was a concern by Cornell University that their entries for 2-4s events had been ruled out of order because they were late, and this was only because they didn't know about the deadlines and so on. And after a lot of toing and froing and pressure from no fewer than 21 heads of house of Oxford colleges where they had boat clubs and similar numbers from the other university and various other clubs, the stewards eventually allowed one of those crews to compete but not the other, which just made the whole thing a whole load worse. But then the crew they didn't allow to race went on and raced in Vienna a week later, and it turned out that the stroke man of the crew had sold the race, and there was then a great row about why on earth they'd been allowed to compete in Vienna in the first place. And it was suggested that the stewards knew more than they let on when they refused the entry. So about 100 years earlier, there's a certain amount of intervention in arbitration of decisions on these things. And amazingly, it happens to involve quite a lot of Oxford people in the process.
Well, that's a great credit to the university. As far as the second is concerned, actually, it's quite interesting. I mean, the boat race itself has generated a certain amount of what I'd call internal arbitration as well as dispute, most notably in recent years when the question is whether the criteria for being a student sports person has or has not been observed. I mean, I did have to advise the University Boat Club. You may remember a few years ago, someone who was meant to be a student sports person, the moment the boat race was over, went back to Germany and participated in the German Olympic crew. And I remember saying, well, actually, if you look at the rules which govern the sport, he wasn't actually, I think, eligible. But I said, you might as well let it go and just simply say, well, afterwards in conversation, or even perhaps putting an asterisk against the result, Cambridge rode with someone who wasn't strictly eligible, but don't take it further, it'd be undignified. And those issues still go on. I mean, we've had them last year. I remember when James Cracknell, the famous Olympic double medalist, rode for Cambridge, and the question, well, he was a student, but was that really the sort of person for whom the boat race was designed? So this is a perpetual problem, and I don't think it's likely to go away ever. Just going back to your first point, absolutely. I mean, we do all know that behind the Iron Curtain, people were being subjected, involuntarily, no doubt, to various forms of drug treatment. There were men who developed breasts as a result of this without the intervention of the Green Party leader at all. But there were other women who died early and suffered. I mean, I always think one of the great unwritten stories, and I never quite understand why our sports journalists never got onto it, was Florence Griffith Joyner. You may remember Flo Jo, as she was known, a double gold medalist at the Los Angeles Olympics in 1984, who died, sadly, very early, about 38. And everyone believed that she must have been taking drugs because her times are still world records, and it's inconceivable that that would have been done without artificial assistance, but no sports journalist ever managed to track this down. So what I'm saying would be defamatory were she still alive. Mercifully for me, she's not. I think we probably have time for one more question. Yes, sir. Oh, well, were any of them great at all? I'm sorry, are you talking about specifics in sports law? Oh, well, there's no question about that. I'm most proud of getting Chrissy Ahurugu back into the Olympics. And I mean, it was a unique experience to watch someone from the bird's nest in Beijing win a gold medal, our only gold medal, when but for me and my colleagues, she'd never have been there at all. You can't get better than that for an experience of a triumph such as it is from a sports lawyer. Well, if that's, Robert, can we conclude that?
That was absolutely fascinating and hugely entertaining, and we've learned a great deal there. Thank you so much indeed for joining us.